Hi, my name is Nicholas Deshan and my student ID number is 0347786. In this context, I'm going to present the relationship between international law and domestic law. So, what is international law? International law includes those rules and norms that regulate the conduct of states and other entities which at any given time are recognized as possessing international personality. Most of the time, states act in accordance to international law. Also, international law cannot prevent its own violation, like municipal law. Municipal criminal law cannot prevent its crimes. When international law breaks down, it is more the fault of the operators within the legal system than the fault of law. International law is decentralized and is founded on the consent of states to accept obligations that limit their behavior and is made primarily by treaties and customary law. So treaty only applies to the states which have agreed to its term and states are able to opt out. Treaties can be bilateral, which means that they are between two states, or multilateral, which means they are between several states. So there is also a distinction between lawmaking treaties and treaty contracts. For lawmaking treaties, it can only create by particular law between the signatories. For example, the North Sea Continental Shelf case is one of the agreements which declared the existing law or codified the existing customary rules. And for the treaty contracts, they have many signatories and create law. So, custom is a practice followed by those concerned because they feel legally obliged to behave in such a way, and it is described as evidence of a general practice accepted by law by the Statute of International Court of Justice. It is important that it is done out of legal obligation or a feeling that violation would produce a legal consequences. For example, in the case of Good of Mine in the year of 1984, this case stated that custom is ideally suited for the development of the general principles, and it is always available to fill the void should the detailed legal regime of a treaty fail to gain universal acceptance. However, when it comes to relationship between international law and domestic law, it is vital to consider the conflict between dualism and monism. Both concepts imply the existence of both international and domestic law. The dualism doctrine establishes a distinction between international law and domestic law, establishing them as separate legal orders that govern different subjects. Therefore, while international law governs the relationship between sovereign states, domestic law grants rights to individuals and entities within the sovereign state. In this regard, the use of international law in domestic courts can only be permitted through a domestic law instrument that confers such rights. According to the dualism principle, in the event of a conflict between domestic and international law, domestic courts would apply the former. On the other hand, monism asserts the supremacy of international law within the domestic sphere and refers to the individual as a subject of international law. Although monism has a clear logical and equitable basis because it prevents states with greater capabilities from imposing their own legal rules as the highest and most sophisticated authority, it is argued that this doctrine directly contradicts established legal rules. So, when discussing the methods of coordination between domestic and international law, academic perspective challenge the followers of monism and dualism's assumption that the two legal orders share a common field of operation. According to Sir Fitzmaurice, the two systems operate in distinct domains. This gives them equal supremacy and prevents them from engaging in conflict. When a state fails to act in accordance with international law, there is a conflict of obligations rather than a conflict of laws. As a result, the consequence will concern that state's position on the international political stage, but will not call into question the validity of its internal laws. So, the legal position on the relationship between state obligations and domestic law is unambiguous. A state cannot use provisions of its own law to defend itself against claim for alleged violations of international law. This rule was demonstrated in the case of Alabama claims arbitration, in which the United States was awarded damages against Great Britain for breaching its neutrality obligations during the American Civil War. It is also decided in the Free Zone case that France cannot rely on its own legislation to limit the scope of its international obligations. Furthermore, It was stated in the advisory opinion in the Greco-Bulgarian community's case that it is a general accepted principle of international law that in the relations between powers who are contracting parties to a treaty, the provisions of municipal law cannot prevail over those of the treaty. If a state has signed a treaty and its domestic law violate any of the treaty's provisions, the state must change those laws in order to meet its international obligations. So, furthermore, municipal court decisions must be taken into account because they provide jurisprudential guidance on the effect of a specific domestic law. The relationship between international and domestic law should be regarded as one of the collaboration and symbiosis. As a result, doctrine and concepts created by domestic law should be recognized by international law. This argument has practically implications when considering the admissibility of municipal court decisions in the International Court of Justice, in other words ICJ. The Permanent Court of International Justice, the predecessor to the ICJ, decided in the Brazilian's case that municipal court decisions must be given due consideration because they provide jurisprudential guidance on the effect of the particular domestic law in the municipal sphere. Although international law is primarily applied in accordance with the court's decision, it is reasonable to expect that parties will rely on provisions of municipal law as part of their arguments. So consequently, when legal issues arise that are not covered by international law, the relevant rules in domestic law will be referred to. In such cases, the court cannot openly disregard domestic law because no relevant international law provisions can be applied. So, onto the United Kingdom's perspective concerning the applicability of customary international law in the United Kingdom. It is a well-established principle that customary rules are enforceable in English courts if they do not violate an Act of Parliament or judicial authority. The legal position dates back to the 18th century, when the Courts of King's Bench described international law as an essential component of English law. Before considering the issue of enforceability, the courts must first establish the existence of the particular customary rule and the scope of its effect in municipal law. So, the latter requirement clearly demonstrates the subsequent invasion of the dualistic approach into a domain that is generally based on monistic beliefs. So, if a customary principle contradicts a statutory or common law rule, it will be ignored. However, as Lord Denning pointed out, when a previous judicial decision is based on an old rule, international law, a customary international principle can override it. He also emphasized that the doctrine of incorporation is an effective principle of English law because courts have previously recognized changes in international law rules without the need of enabling Act of Parliament. So, in general, the existence of international law doctrine is taken into the account by the courts. However, in order to invoke a customary international law principle as part of English law, there must be evidence of assent to incorporate it, or the principle in question must be jus cogens, which means no derogation is permitted by the way of particular agreements. Lord Justice Akin affirmed this position in two significant decisions, emphasizing the importance of seeking existing evidence of implementation. So according to him, no external power imposes international law rules on English law. As a result, an international provision is ineffective unless it is incorporated into domestic law using one of the aforementioned tools. So, for treaties, there are only legal binding in England if Parliament passes an act to that effect. This is regarded as a constitutional law principle rather than a construction rule. This distinction is significant. When Parliament passes legislation to implement an international treaty, the courts will not apply the concept of parliamentary sovereignty as a rule of construction because it would distort the primary purpose of the legislation. Instead, the court will use the presumption that Parliament intended to achieve its international obligation as a rule of construction. This is based on the assumption that parliamentary sovereignty extends to breaking treaties, in which case the party harmed should seek redress from the legislature rather than the judiciary. To invoke international law, the terms of domestic legislation must be open more than one interpretation, and there must be peremptory and stringent evidence of an an intention to enact the relevant international legislation. There is no need, however, for the English statute to expressly grant permission to refer to international legislation, as doing so would create the perverse presumption that Parliament intended to violate an international convention. Even if domestic provision is clear, the court may refer to the text of international legislation to provide context. For example, if there is a conflict between the English text in the domestic statute and the foreign text in the convention, the courts will apply the latter because Parliament intended to give an effection to an exact translation. So, onto Malaysians' perspective. Unlike the constitution of some other countries, the Federal Constitution of Malaysia contains no provisions stating that international law is part of the law of the land or that treaties are the laws of Malaysia. However, certain provisions of the Malaysian Constitution deal with treaty-making capacity. For example, Article 74, subclause 1 of the Federal Constitution states that Parliament may make laws concerning any of the matters enumerated in the Federal List or the Concurrent List. The ninth schedule of Federal List includes external affairs, such as treaties, agreements, and conventions with other countries and all matters which bring the Federation into relations with other countries, and implementation of treaties, agreements, and conventions with other countries. So we can conclude from the wording of Article 74, read in conjunction with the Federal List, that the Federal Parliament has the sole authority to make laws relating to external affairs, again, including treaties, agreements, and conventions, as well as the authority to implement international treaties that make them operative on a domestic level. Besides, the case of the government of the state of Kelantan against the government of the Federation of Malaya and Tunku Abdul Rahman Putra Al-Haj, Kelantan challenged the constitutionality of the Malaysian agreement because it was an international treaty signed by the United Kingdom, Singapore, the Federation of Malaya, Sabah, and Sarawak. The main argument proposed by the Kelantan government was that before the arrangements for Malaysia could be lawfully implemented, the consent of the individual states of the Federation of Malaya should have been obtained. However, Article 39 and 80, subclause 1 of the Federal Constitution stated that it is not mandatory to obtain consultation with any state government or the ruler of any state, as the Malaysian agreement is signed for the Federation of Malaya. So, for customary international law, Malaysian courts appear to have applied it in practice when the occasion arose, even though the application is indirect. But through the English common law, in other words, Malaysian courts incorporate customary international law into common law. For example, the case of Olofsson against Government of Malaysia concerns about the rule of customary international law relating to the immunity of a sovereign state from judicial process of a foreign country. It was held that the case that as Malaysia had become a sovereign state from August 9 in the year of 1965, and the court has no jurisdiction to entertain any action or other proceedings against the government. So, a treaty which to be operative in Malaysia needs legislation by Parliament, as the executive body possesses the treaty-making capacity, while the power to have legal effect domestically to treaties rests in Malaysia, just like in United Kingdom. So there is a possibility to say that there are treaties that can be implemented locally without the need of the passage of legislation. Nevertheless, treaties that affect private persons' rights or involve changes in municipal law must be accompanied by legislation. One of the examples of statutes made by Parliament to give legal treaties concluded by Malaysia will be the Geneva Conventions Act 1962. So, that's all for now. Thank you for listening and paying attention throughout the presentation. I hope there are new things you can learn from this presentation. TTF Nan, tata for now. Bye bye.